It's been 5 years since the Indian Parliament passed the Insolvency and Bankruptcy Code. It's been a mixed journey so far for the IBC. Hi, I'm Joel Rebello and from the Economic Times, and I'll take you through these 5 years and the hits and misses from this new code. When the IBC came or was passed by the Parliament in May 2016, a lot of expectations had been built on a new recovery mechanism for banks. Viewers may remember that before this mechanism came into play, banks had little recourse except the courts to get their money back from defaulting creditors. There was the debt recovery tribunals, which were taking their own time to resolve cases. And there was a SARFAESI Act, which gave banks a provision to take over assets. Time taken on these cases was long and winding. The IBC was, in a way, a breath of fresh air because it gave a clear mandate of cases being solved in the 180 days. So this timeline was the big draw for IBC. And more importantly, banks had a recourse to take a defaulting debtor to the courts and to resolve these issues and to take back their money. Suppose a company A has defaulted for a 100 crore loan. He is not paid. He's been declared as an NPA. The bank will send him reminders to say that please pay back. If he doesn't, probably he will send him a notice saying that we will try to take action against you in court. Then they will probably take him to file a case against him in the National Company Law Tribunal. Whenever the case is admitted, again, admission is again a bone of contention in terms of delays because of very few members in the NCLT. Appointments by the governments have not picked up pace. Whenever the case is admitted, the creditors meet. They open up bids. People bid for the company, and depending on the best price, the COC or the Committee of Creditors will decide whoever they have to give the company to. Of course, all this process has to be, given the go-ahead by the NCLT and given the approval by the NCLT. It's been a mixed journey in the last 5 years or so. While the recovery rate for banks has increased, the delays in the IBC has also been elongated in the last couple of years. Of course, COVID pandemic in the last fiscal has compounded these delays. But the fact of the matter is long winding court cases and challenges by powerful debtors has actually delayed the process in the IBC. So far, if you look at it, till March 2020, about the recovery rate for the IBC was about 46%, which is very good because if you compare it with the previous DRT and SARFAESI, it was only 26%. So this was a big recovery difference, almost double of that. If you really look at it together with the assets which have been liquidated, the recovery rate has been much more lower. It is closer to 20%. So a macro picture, if you really look at it with liquidated assets, is lower than the previous system. But one thing to notice here is these liquidated assets had no takers. In other words, they were out there, and for many years there have been bad loans for many years, and there was no other way for banks to get any value. What IBC has done is created a system for banks and creditors to go to courts to recover their money. What it means is that defaulters who were earlier probably relying on courts and probably trying to grease the system by delaying their matters have had to now come to the table and talk to banks. That's been the biggest advantage or the victory for banks in this system. There's the one-time settlements for banks through this system has increased quite rapidly, and banks have to only basically suggests that they will go to the NCLT, and probably defaulters are fearing that they will lose their companies, are coming to the table to settle the matter. Why this has happened is because some marquee companies, for example SR Steel, though it took 3 long years for the case to be completed, but banks recovered more than 100% or close to 100% of their outstanding amount. And it also sent a signal to large corporate borrowers that a default will now no longer be tolerated. Delays have been the bane for IBC. Over 79% of the cases are beyond the 270 day time frame set out by law, which means that the asset value also erodes over time. Banks do not have the wherewithal to continue to chase these assets. The value is not as much as it is in the initial period. And of course, the delays, which means that defaulting promoters can try different kinds of tricks to get ahead or avoid paying, or probably delay in payment. So that is the big bane. If I think the government is cognizant of the delays, and probably changes in regulations are in the anvil, and if they follow up their words with action in terms of appointments in the NCLT, we could see cases picking up, resolutions picking up, and IBC as of now is the best law for recovery. There is no other option. The old DRT surfaces still work, but this is the best way. This is the most transparent way. So the future is in the IBC, of course, with some tweaks.